Welcome back to Her Tell. Okay, excited about this one. Been wanting to talk to her for a while. We keep crossing paths on lines and then different things. Never actually got to talk to each other. That's the beauty of the medium. Ashley Barker's with us. She's from Public Policy, does that for the Committee for Justice, a bunch of other things, Federal Society. She also does antitrust, but we're going to talk some lawyering today, Supreme Court stuff. Ashley, how are you? Great to finally have you on the program, man.
Great. Thank you for having me.
Thrilled to have you. Okay, we have the inevitable headline that we've kind of been waiting on. It was a matter of when. The leaker of the Dobbs decision, the Supreme Court came out with their statement. Dare I say it was a very lawyery statement. The bullet point on it was, and I'm quoting here, they could not find to the preponderance of evidence who leaked it. That caught my attention. I don't think this is a case where they don't know who it is. I think this is a case where they either can't prove it or don't want to reveal it. How did that statement come across to you as somebody that really follows this really closely?
Sure. Thanks. So I think you're correct, Jay. First of all, it is very long overdue. It's been over, I think, 9 months now since it was May 4th or 5th when the draft opinion was originally leaked. And you make a good point too about the preponderance of the evidence. So of course that, you mentioned it as sounding lawyerly, and it's not as if such a statement needed to have a preponderance of the evidence standard versus, a reasonable doubt sort of standard. And I think you're correct too, and that was my reading of it on first impression, is that they do have, a suspect or a small number of people that they suspect did it, but they lack the actual evidence linking it specifically to that person, whether that be, a digital footprint or fingerprint or whatever that sort of evidence is. They don't have enough to definitively say we have a piece of evidence that implicates this person. But the fact that they said a preponderance of evidence, it does mean that they weren't looking for. It would be different if it were like, well, we couldn't prove beyond a reasonable doubt. We're not 100% certain. There could be some doubt. No, it's just that they were missing a key piece of evidence, and that could be because of the IT systems of the court. Probably not surprising that they're stuck back a few centuries ago in terms of their systems and protocols and other things. So it seems that they were inconclusive in their findings, which was really disappointing from my perspective.
Ashley Baker joining us. It's funny when you actually read through the report here, not just what the marshals said, but they also brought in an outside report as well. It's funny here, the Chertoff group, of course, Michael Chertoff, familiar name in Homeland Security circles. It's funny here, you mentioned the technology and the digital footprint. It almost seems like what they couldn't handle here is in their interviews, and they didn't get to interview everybody here. That's important to note here. They talk about things like what we would used to call pillow talk, like, well, they talked to their spouse. Did they mention it? A couple people admitted they mentioned it in that way. It's not just technology. This is just kind of a human nature thing you're fighting here, isn't it? Which is somewhat something the law's been dealing with since we first started having law, right?
Yes, I agree. It's one thing, yes, it is something that we've been dealing with, human nature, and it seems that it was probably a printed copy that was shared one way or the other. But also, I don't think we've dealt with this level of activism that we have today. And other cases as well. It's just that the types of students who are coming out of places like Yale today are the types who would see it as this is being something that's permissible, something that they should do, and that just was completely out of the question beforehand, I think.
Yeah, Ashley Baker joining us. Let's back up then, because it's important to keep the perspective here. We haven't had a leak like this in modern times with modern technology. There's some stuff back in the early days of the court. Look, the Supreme Court has some dirty laundry like every other government organization. If you go back, especially in the early days, there's some real questionable characters involved. But this is new in the modern time. I think it shocked people. Walk people through it just real slowly, though. This is a court that's still trying to figure out the technological aid. Look, we just got recordings of live court hearings because of COVID stuff. That's almost like the dam breaking in a lot of ways. The court is very slow to adapt to the public. That's the environment this all happened in, and that's why this came as such a shock when we had this breach of protocol.
I think so. You're correct that the courts slow to adapt to the public with COVID, but in some ways they've been good, such as oral argument format, for example, I think has actually become a little bit better as a result of the pandemic, and it's great to be able to listen to that in real time online. So that's one thing that they did well. The other thing, it's not surprising that the Supreme Court barely had a functioning website during part of the month of June until about 5 years ago. It was like every June the Supreme Court website on opinion day would crash once or twice, and everyone would go find the opinions on SCOTUS blog. It's bad enough that, once essentially the PR arm of a boutique law firm became the go-to source for Supreme Court opinions for many years, which is absurd if you think about it, because you should be able to just go to the government website and find that document. In terms of, the sharing of documents, being able to take them home, that process working differently, work at home aspect of it, yes. Whether or not different protocols and those, which I think the recommendations in the report are solid, whether or not that would have actually stopped this from happening, it's really hard to say. I mean, it could be, someone could leave a printed copy in, a cafeteria in the metro, like they could leave it at home and their roommate or their spouse or whatever could see it. So it's not completely foolproof, which is why I think it's also important that there are consequences for this sort of action.
Yeah, Ashley Baker. Let's talk about that for just a second, though, because we just walked through it a little bit. The Supreme Court, when it's these court cases, I think, and I would hope, look, I've become real big since I started doing editing and writing and stuff, is get to the source documents, right?
Mm-hmm.
This stuff is not as intimidating to read as I think people think it is. Dobbs may be the first time people really actually tried to look up and read a decision themselves. For just the average person that's not a lawyer, but they just want to keep up with, look, the Supreme Court is so entwined now, especially with, kind of the breakdown in the legislative system. If there's a theme of the Roberts courts, it's Congress needs to fix this, we shouldn't fix this. There's a lot of back and forth here. For the average person who keeps seeing the Supreme Court pop up, how should they go about reading these, getting the source documents? I know you mentioned the SCOTUS blog. It's a great website. I use it all the time myself. But you can just get the straight PDFs for this stuff. You can find the source doc. You don't have to take a talking head's word for it on either side, because both want to spin this to their own ways. How do they go about actually getting this information? Because I think this is one of those things we could self-educate ourselves and get through a lot of this mess in a hurry.
I think so, but I think a lot of people too, even when the link is provided, want the short, quick, regurgitated version, and some people want the version of it that aligns with their beliefs. So there's always going to be an element of some people not reading, the source documents. I mean, and working in other areas, and let's say antitrust, for example, there are plenty of people who do not read the cases or not read the thing that they're responding to. But that said, I mean, for those who are inclined to do so, one thing that I would suggest is either SCOTUS blog. It's a great suggestion. They always print a link to the document. Also, the Supreme Court website, like I said, which is now easier to access and easier to navigate on the page than it used to be. And also following reporters on Twitter who consistently on opinion days, particularly in June when all the opinions come out very quickly at once, who provide links to the documents. Like find those reporters and follow them.
Yeah, Ashley Baker. Okay, talking about following stuff. Anytime we have a huge story like this leak, it puts my radar up on, because like, well, wait a minute, the Supreme Court's working right now. They're going through things right now, and everybody's talking about this. What are we missing that the court's doing right now? Because we don't have the big ticket like a Dobbs going right now, but we got some really important cases working through the court right now. We also have some things that they're going to review. What's going on that's missing in these headlines and the rush of the coverage of the Dobbs leaker?
Well, kind of going back to Dobbs specifically, and the harm that the leak does is it's to that process. It's to the deliberative process. After this draft was actually, the date stamp was February 10th or so, I believe. It was early to mid-February, and it was leaked in May. And during that time is used to deliberate with the other justices, for other justices to write dissenting opinions, concurring opinions, dissenting in part, that sort of thing. So what's really being impeded is that process, which does require cooperation across chambers. And I think a lot of trust and ability for clerks to work with one another has been eroded. I don't think this necessarily means that justices won't trust their own clerks. I don't think that the trust that's eroded is like vertical, so to speak. I think it's between the different chambers of the court. And as of what's going on right now, I mean, it's most of the opinions come out in June. Oral arguments have been heard in quite a few cases. We have quite a few to go, and there's kind of this rush to get out opinions towards the end of the Supreme Court term, which usually ends at the very end of June. They'll extend it by a week or so, and that's when most of the opinions of the court come out, especially the more complex opinions that take the justices a bit more time to get through and to write various concurring and dissenting opinions.
Yeah, Ashley Baker joining us. For folks that aren't familiar, though, let's just make sure we don't skip over this too far. That the Dobbs leak, it actually had first draft stamped on it. Like you could read the stamp on the copy that got out. Talk about that process a little bit. You're talking about cross chambers. The justices don't just write an opinion and submit it, and it's not like turning in a work at school, right? They write it, but then they pass it between themselves so they can refine their arguments. They can refine, whoever's in dissent, who's ever in the majority. They work through who's going to be in what. There's a negotiation is probably not the right word, but for something that everybody can get their heads around, they refine these opinions down based off what each other's writing. That's why a draft leak was so damaging, because they got to trust each other. Like, all right, here's how I'm going to disagree with you. Scalia was famous for this. He would actually send his over as early as possible. Like, here's what I'm saying, write what you're going to dissent off what I already wrote. There's not just a camaraderie there, but there's an important part of the legal process there. And that's what gets damaged by this.
Yes, absolutely. I mean, and the duty of the court in writing these opinions is partially to explain to the public how exactly we arrived here, what our rationale is. And if you notice the final version of the Dobbs opinion versus the one that was leaked, the only difference is really we're responding to the dissenting and concurring opinions. The opinion itself and the number of those who were in agreement with it, all of that remained the same. It kind of, I think it, as soon as it leaked, my first thought was, well, this is probably locked in at this point. And I don't think that was necessarily their motive, but I couldn't see the possibility of someone flipping, because they would forever be known as that justice who flipped in Dobbs.
Yeah, I thought the same thing. And then the other thing I thought was, and I don't want to do conspiracy theories here, but like it had to be one of the, and there's different levels of clerks. The clerks that would have access to a draft copy, that's a very small number of people. And the justices. The two concerns is, was it a clerk or was it a justice? It almost seems like it's incalculable that it would be a justice, but the way they've handled this, they kind of left the door open for the conspiracy folks to think this might have been a justice. I don't want to speculate on it, but if it was a justice, that's really not good.
I mean, I think there's virtually no chance it was one of the justices. None from either side of this case would do this. I think there's too much respect for the institution amongst the justices. And also thinking about this too, just from a purely practical perspective, they're appointed to the court for life. They have to work with their colleagues as long as they're there. It would, from a purely practical standpoint, I mean, obviously, other than just being wrong, it would make no sense to do this. Nor would they be able to persuade their colleagues to go one way or the other by doing that. There's just absolutely no good motive there.
Yeah. Ashley Baker joining us. Okay. That's that story. What's coming up in the Supreme Court here? You just went through the timeline a little bit. Usually we get the big announcements, May, June, July kind of time period. What's the stuff folks should be watching out for this spring that the court's going to be watching in the headlines as they follow along?
Well, there are quite a few big cases that will be in the headlines. The court recently has not been shy. I mean, Dobbs is evidence of this. The fact that they've been granted it, they're granting cases now that aren't as non-controversial, aren't as necessarily incrementalist as the court did in years past, which I think is a good thing to reevaluate some of these larger issues. There's a large case involving affirmative action and college admissions that will be coming up. That was certain to make headlines about whether or not racial preferencing is discriminatory, and if it's discriminatory against particularly Asian students in this case. There are some administrative law opinions, as always. There's a pair of cases, Axon versus FTC and SEC versus Cochran, that will decide some issues of federal jurisdiction, or whether constitutional claims need to be heard like in-house, like in that agency, or if that needs to go to federal court as it would in pretty much any other case. That's a narrow and kind of wonky case, but I think it's pretty significant in terms of where the court's going in administrative law. There's a copyright case as well that involves the Andy Warhol Foundation, that the court's going to kind of explore what is fair use, what is not fair use when it comes to reproducing certain images in which he did not have a license currently to do so.
Andy Warhol still causing trouble in the year of our Lord 2023. Ashley Baker joining us. Let's one more thing about this Supreme Court, though. People do look, it's a narrative. I don't like it because I don't like to waste my time on things that are a waste of my time. There's this whole narrative in the news media about the legitimacy of the Supreme Court. Well, the Supreme Court, I understand the terminology of legitimacy, but the problem is legitimacy is in the eye of the beholder, and these people have lifetime appointments, so it really doesn't matter whether you think they're legitimate or not. However, having said that, I wonder if this is one of those things where it's just people are more aware of how it works in the inner workings and they're applying it through the polarized political filter. I think that's more the story. People are viewing the court because the court, it comes and goes. It gets liberal. It gets more conservative. It'll swing back more liberal at some point. These things go in cycles. I think people's awareness of it is just higher. And with social media, people like to use it for their own means. I think it's how we're viewing the court is the real story here, more so than the court itself. Is that a fair way, do you think you put it?
I think so too. The bigger problem here is that people view the courts as making policy, and when that policy has kind of gone their way for many years, and now it's suddenly not, you see this huge outcry when really the outcome in Dobbs just means that this decision is not the job of the Supreme Court. We return this to the legislature, to those who are represented by the people, those who are the elected representatives that are closest. So it's not, it's that they gave away power. You'll notice you don't see anyone really making any strong arguments for why Roe should have been upheld. It's more of, why not to overturn Roe. And at the end of the day, I think Alito did a really fantastic job in his opinion. I think that's one thing that's a little bit underappreciated just because of all the discussion of around the leak, is how great of a job Justice Alito did and just kind of laying out several reasons of which you kind of look towards and deciding whether or not a precedent should be overturned. And at the end of the day, he says, look, Roe held that there's an abortion right supposedly somewhere in the first or fourth or the 9th or 14th amendments, but where is it? They can't pinpoint a certain, those who are in favor of Roe can't pinpoint exactly necessarily where that is. And things kind of with Casey and other precedents just kind of evolve from there. So if it's not in the Constitution, then it's up to the elected representatives to decide.
Right. Ashley Baker joining us now. Of course, our progressive friends and those that support abortion rights are going to disagree with Alito, usually pretty loudly. Here's the thing. This is all these state laws that were enacted. Some had trigger laws. Some went back to the legislature after this happened. This is not the end of the abortion debate. This is the middle of the beginning of the end of the beginning, right? We're going to see more court cases in the future with all these new state laws coming and all this. How long a period do you think it is before the Supreme Court takes up abortion again? 3 years, 5 years? Will it be the next court after the Roberts Court? At some point, we're going to go through this again. What do you think the time frame is going to be?
Well, I don't think it would be in the context of Roe specific. I mean, Roe, that was one of the good things, and from my perspective, in Roe being directly overturned and not just kind of left hanging, such as the court has done and certain First Amendment cases, for example, and not fully overturning something. I mean, this is one of the first times in 200 years almost that the Supreme Court has kind of relinquished power to the legislatures. So any case that involves those state laws might come in a different form, whether that's in the realm of administrative law or commerce or something kind of more specific to that. But whether or not there's a constitutional right to an abortion, that issue has been pretty well settled now.
Ashley Baker. Okay, this was heavy stuff. Let's have a little bit of fun. One of the internet, especially Twitter and Facebook's favorite things and favorite conspiracy theories is the marshal of the Supreme Court and what they do and don't do. One little ray of sunlight in this Dobbs thing. We actually had a legitimate sighting of the marshal of the Supreme Court and what they actually do. So break the meme down and the conspiracy theory down for what does the marshal of the Supreme Court actually do, since we actually got to see them do their job here.
Well, if you look at the process involving the investigation, I don't know how I think that kind of started as a little bit of a joke because it is called Marshal of the Supreme Court. It sounds, you can imagine someone and what they might be wearing and like it's a 18th century sort of depiction. But there in terms of the processes involving the security of the court itself, of the premises of the justices, they run that whole operation sort of.
Yeah, I think people think it's like Black Rod at the opening of Parliament in UK. They got the big fancy hat and a big stick, and they bang on the door. And that's not what that is.
The stick.
All right, little bit of look. Even the Supreme Court's got to have some fun once in a while, right? Ashley Baker, she's with the Committee for Justice. She also does some antitrust stuff. We're gonna have her back to talk about that. But my friend, until we get you on Her Tell again, let folks know where they can find you, how they can follow you, and keep up with what you're doing until we talk to you again.
Sure. And thanks again for having me. So you can find our website is committeeforjustice.org, or you can find me on Twitter. My Twitter handle is @AndAshleySays. and you can find me there under Ashley Baker.
We will do it. We're going to link to all this stuff. We'll link to the various things she has. I'm also going to link to that direct report. Like we just said, read it yourself, short document. It's short. It's only about 2 pages, and the Chertoff stuff's about another 6 pages. Read it for yourself. Ashley Baker, really appreciate the time. We'll do it again soon, my friend. Thank you.